today to kind of look at is to look at IP rights, because this kind of actually, Shona, you were at the table when we were discussing it with some of the heroes outside of Norskin. And I was, I suppose, surprised by some people didn't really fully understand kind of what the value was of their IP and even what IP they had. And it is just so crucial for you all to understand and kind of assess and even audit, if needed, the IP rights that you have as a company. And I think maybe people think, oh, I'm going to have to spend a lot of money. But actually, what I really want to try and flesh out is actually it's a very easy, cost-effective way of looking at the value of your company in another way. You know, not just the numbers, actually the ideas behind the ideas behind the concepts, the plans that you have done, the database, the software, and so on. So your IP is really kind of one of your core assets. So today, what we're going to look at is, and some of this may be basic information, but I think it's good that, no problem, Elmarie, thank you. So we're going to look at kind of main IPRs. What are the main types of intellectual property rights? So when I say IPR, that's intellectual property right. IP is intellectual property. Looking at registrable and non-registrable IP. And then what I think is really important to kind of really hit home is IP, which is developed when you have employees and consultants. So what we will... so what are IP rights? So kind of as the name suggests, it's the product of a human intellect. So that's why it's called intellectual property. Intellectual capital is really one of the most important assets of many of the world's largest and most powerful companies. And a lot of them have really got to where they are from making sure that they've properly identified their IP and protecting it. So what you get with IP rights is it refers to, as you can see in the second bundle, in the second paragraph, it's a legal right. It's a bundle of rights, which gives you ultimately exclusive ownership and the rights over the use of a certain asset or kind of creation. And you can also importantly have the exclusive right to prevent others from using and or exploiting that creation. The role of IPRs in business is really insufficiently misunderstood in my view. Most often it might be undervalued, undermanaged, or underexploited. So I really want you just to kind of think about what you have and really make sure that you kind of properly understand it. So the main types of IP rights that you have are here on the slide. So typically you'll see copyrights in your work, patents, trademarks, industrial designs, and then trade secrets. If you're looking at your IP for the first time, you might be surprised actually how many IP assets you even have. Maybe you don't realize, for example, that you have industrial designs in any of your products. So it's really important to kind of look at these in kind of a line item, and I'll be sharing the slides after this session, and try and understand, okay, where do we have copyright? Where do we have trade secrets? Do we have patents, for example? So really kind of use this as a checklist of things to go through and understand. So the IP rights that you need to look out for need to be distinguished between those rights that can only be protected through registration. So for example, a patent or a trademark, but also what I think is the most cost effective for you all is those rights that you actually don't have to register and actually exist either through kind of creation themselves or even through proper protection, internal protection rather. So we have copyright, which is the basic, right? So copyright really protects original works of authorship, and it protects the expression of an idea or a concept. It's not the idea itself. So you can't say, aha, I have my light bulb moment. I have this fantastic idea to send a balloon to space. Okay, that's your idea, but then you have to put it down. You have to explain how that idea kind of has come about. It has to be in writing. So that is really kind of the trick to protection, right? And it's very easy. What it protects is, what copyright can protect is original writing. It can even protect web content, sound recordings. It can protect software, databases, so your customer lists, for example, your sales records, and in some instances, your business contacts. The next one is trademarks. I think most people, this is probably another familiar right, and it's really your brand of origin, particularly if you are consumer facing. Really important to make sure that you register your trademark. You know, and it's a distinctive product. It's a brand name. It can be a logo. Some countries, it can even be a color, for example. Then we have design rights. So I know that some of the hearers are, for example, involved in textiles. It's actually design rights can protect patterns, for example, and shapes, and even textures. So, for example, if you have an embossment on any of your paper that you produce or any of your patterns you produce, you can protect that with a design right registration in some instances, and sometimes they actually exist as an unregistered design. We then have kind of the big bad wolf, I guess, of patents, which are really kind of an exclusive right for inventions. And patents protect inventions, kind of novel products or innovative processes. To get a patent, you know, the big hurdle in my view is that you actually have to disclose quite a large amount of kind of technical information in order for you to get the patent registration. An option which I really urge you to look at and really will depend on your jurisdiction is whether or not you can protect your invention with a utility model. So utility models really protect what we call kind of minor inventions. It's a very similar system. You still have to meet the novelty requirements, so your invention has to be new. Same thing with patents, but you don't have to meet a step within a patent registration, which is called the inventive step, or a step that is, you know, non-obvious. So which is the biggest benefit for utility models. You also have a big benefit that the registry won't really examine the substance of your application as much as they do with a patent. It's a lot cheaper, but the registration period is a lot shorter. So please check with your lawyers in your respective countries whether or not you can benefit from utility model protection, because I think it's a very overlooked way of protecting your IP rights. You have goodwill. So goodwill really refers to the value a company gets from its brand. You know, so we know that if I'm in an Uber, I know that the drivers will have been vetted. They have a certain reputation that they uphold in respect of their fleet. It's a real long-term asset that can generate the value for your company over a number of years. When I say kind of goodwill in respect of a trademark, it's really the recognition of your mark amongst consumers and that extra earning power that you can also generate. And then we have the secret IP rights, which in my view are probably the most valuable IP rights that you will have. And these are really kind of protected by the law of confidential information. And actually the law on confidential information can be used to protect a lot that's actually not capable of being protected by any of the other the intellectual property rights. What is key for trade secrets and know-how is that you have to keep it confidential. You have to have proper processes and systems in place to make sure that this information is kept confidential. So, for example, a trade secret is a specific form of confidential information. Typically, it will be, for example, a formula or a recipe. So a well-known trade secret is Coca-Cola. From a tech perspective, even algorithms can be protected as trade secrets. So the Google search is actually, the algorithm for the Google search is protected as a trade secret. Then you have also know-how, and I know they're used interchangeably quite a lot. And it's really, sometimes it's actually, you don't even have a description for what the know-how kind of constitutes. And it's usually typically more technical in nature, and it's the knowledge of a method or a technique of doing something. So Shona, Francine, you might actually have a lot of know-how within kind of, within the industrial process in creating your products and so on. So it's important to understand, particularly for confidential information, because particularly if these are leaked, then you really lose your edge. You lose that value that you have been working on, that you have been developing on, and it's such an easy intellectual property right to protect. So brands, particularly if you're consumer facing, brands are really important to get right. And you can see immediately, I look at eBay, I know what it means. I look at Alibaba.com, I know what it means. I look at Puma, I know what it means. Brands are really kind of one of the best examples of how goodwill is generated, which is what I just touched upon before. So why are they important? Importantly, you've all been spending a lot of time in research and development. You've been spending time trying different products, seeing what works, seeing which formulas work, seeing which audits are the best for your customers. These are all kind of really valuable types of IP. And you don't want somebody else just to step in, take it, and benefited from the 5 years that you've been spending in trying to find the appropriate suppliers and so on. So it's really important to understand what your IP are, just to prevent, parasitic third parties from essentially stealing this value. It gives you that competitive advantage. And particularly if you are growing or kind of expanding, think about maybe you can license some of these IP rights. And then finally, from an investment perspective, an investor will want to know that the company they're investing in owns the IP rights or licenses their IP rights lawfully. So it's really important. It's a really important step that investors will do, particularly in due diligence in your company. So the easy ones are registration of IP. So importantly, IP rights are territorial. So just because you have, for example, a trademark registration in South Africa, it doesn't mean that you automatically have a trademark registration in Rwanda. If you are a consumer-facing brand, I really emphasize the importance of making sure you have a trademark registered. Then patents and industrial designs are also registrable. And then finally, copyright, it's, as I said, it automatically is created, but in some jurisdictions, you can register it. So again, look to see if you can register your copyright with a relevant registry. We then have the kind of non-registrable rights. So as I said, some of the most valuable IP can't be registered. So what you need to look at is, do I need to protect some of these IP rights in some of my key contracts? And we'll look at employment contracts in a short while. But for example, are there NDAs or confidentiality agreements that I should always be having? When I'm making a presentation, should I be sharing this much information about my product or my service? When I am, writing an article, should I be sharing this much information about my product service? So really, I'm asking you just to think about what you have and what you're sharing, kind of more broadly. Then we have looking at intellectual property rights. So in employment consultancy, I think this is a really important point to make sure you understand. Check your employment contracts, check your consultancy agreements, and make sure that they have clauses in those agreements which say any intellectual property rights that are created during my employment or during my consultancy are owned by the employer, by the company. Because what you don't want is a rogue employee or a consultant walking in, taking all your information that you share with them, and then walking out with it and saying, actually, I own this because I worked on this. No, that is kind of your biggest red flag. So please make sure your contracts are watertight in this respect. You might have consultants that, will say to you, this is my bread and butter. I can't assign this IP to you, which is fair enough, and which is, which I understand. And that is where you have, it's called kind of background and foreground IP. So maybe a software developer will have a base layer of code on which they build upon, kind of your e-commerce platform, for example. In those contexts, you know, what you can agree on in the negotiations that you have with your consultancy agreement is to say, fine, that background IP, I understand, is owned by the consultant, but that foreground IP, so the IP that you have, that I have paid for and that you have created specifically for me, must be owned by you, the company. So please make sure you kind of go back and check all these contracts. And finally, kind of that last paragraph, you know, make sure that there isn't a condition attaching to the ownership of the IP. What I've seen is, for example, you'll only own the IP upon full payment, right? But then what if the consultant hasn't delivered their full work or scope? You're going to, you know, evidently want to withhold payment because they haven't provided, you know, what they say they would provide. But then you don't want them to hold the IP as ransom. So this is kind of part of the audit that I'm just encouraging you to check and carry out. Looking, I'm not a tax lawyer, but it's really important that you understand kind of elements in which intellectual property rights can attract tax obligations. So most commonly, licensing or kind of acquisition, and licensing can even be within the company. Check to see if you are eligible for what is sometimes known as a tax holiday in your jurisdiction. So for example, Mauritius, in Mauritius, there's an 8-year tax holiday on income derived by a company from IP assets which are developed in Mauritius on or after June 2019. Your jurisdictions may have something very similar. So have a look, you know, kind of consult your tax advisors and see if there is anything that you can consider. Innovative regulation of IPRs, again, this will be dependent on a country per country basis, but for example, yeah, and maybe, you know, you can get involved in any lobbying for regulatory sandboxes. I think we discussed regulatory sandboxes in one of our sessions at Norskin, but for example, some countries have what's known as a patent box or an IP box regime. And you basically, it's basically aimed at incentivizing R&D by reducing the tax on patent or IP revenue earned during a specific period. And it can be quite a valuable tool just to consider and look out for. We then have the final slide, which I just wanted to discuss, is IP disputes. You know, hopefully you never get there, but you either may have to defend yourself or you might have to enforce your rights against a potential infringement. The disputes that we'll typically see are copyright infringement claims. So somebody's saying that you copied, exactly as it says, that you copied X, Y, and Z from them. They have to, it's quite a high bar. They have to really show that there has been copying. Sometimes you have domain name infringement. So maybe they have taken shonoequip.tech, for example, and that can sometimes be cause for domain name squatting. If you have a trademark registration, for example, that is a very valuable evidence of registration. You have then patent infringement and revocation claims. They're quite hard to enforce, I do have to say, and costly, unfortunately. And then finally, you sometimes have claims for what's called as passing off. So for example, you have Adidas, but then you have somebody who has a similar brand called Adidas. You know, they are trying to say that their goods are very similar to yours. For example, they're passing off their goods as being those of Adidas's, for example. And then IP rights can also arise out of contractual protection. So for example, breach of an NDA, breach of an employment agreement. So these are just things to be aware of. Particularly if you have kind of important IP that is important to protect, make sure that you have the budgets for this. So same with registration, same with enforcement. There's no point having a registered IP right, or there's no point in having valuable IP and you don't enforce it, and you essentially allow other parties just to, you know, to use very similar kind of IP to yours, and you let them carry on with their business. So what I want you to kind of go back to is understand, you know, what IP does my company have? What do we develop? What do we generate? What do we use, for example? Are there any really key designs or systems or innovations or lists or recipes or supplier names, for example, that are really kind of integral and valuable to your business, that actually if somebody else had them, you would suffer quite a big detriment as a result of that. If you're expanding into other jurisdictions, you need to consider, for example, for trademarks, do you need to register your trademark in that country? Is there somebody else that has a very similar trademark to you? Do you need to rebrand? Do you actually think about your intellectual property rights when you're negotiating kind of contracts or an employment contracts? Consider the internal processes that you have and consider, am I really looking after confidential information properly? Am I leaving it out? Can anyone access it? Is my laptop kind of available to all of my senior staff, my HR? Are certain folders on your cloud drive accessible to all? So this is, these are really easy organizational steps that you can take, which don't kind of involve legal fees and really kind of come from an organizational tidy up. And then finally, is there a way in which maybe you can derive more value or revenue from your IP?